on putting himself, no, he didn't have his children with him. I guess we're lucky on that, but he put everybody else at risk after drinking excessively twice and getting behind the wheel. Good morning. This is the time set for case D216357772D. We have counsel make your appearances, please.
Morning, Your Honor. Thomas Standish, Fort Dillon, Houston. My phone number is 1424.
Morning, Your Honor. Dana Dwiggins and Ross Evans on behalf of Julie and Paul Page, who are present with me today. And then Lexi Page is also present as well.
All right. All right. Have you guys been able to talk and work out any of these issues?
No, Your Honor.
Okay.
We have not spoken at all, so.
All right. So I've reviewed what's here. I haven't reviewed everything in this case because there are frankly currently 347 documents filed in this case. So I've reviewed what you guys have provided as well as the last order from Judge Henderson. This court has exclusive continuing jurisdiction. Temporary orders were entered by Judge Henderson after a long hearing on April 17th, 2024. And the order was entered on May 1st, 2024. And a stipulation and order was also entered that affected that order on May 16th, 2024. As a general rule, when a case is moved from one judge to another, judge number 2 does not modify the orders that were just recently entered by judge number 1, especially when judge number 1 in this case oversaw about 2 years of extensive custody litigation. But based on what I reviewed today, the court does have safety concerns about the children being in dad's care. Some of those are mitigated by the fact that the interveners have agreed that he no longer needs supervised visitation. But my concerns are drinking. The backtrack summary shows 3,179 total tests and 1,606 of those are missed. That's not even 50% compliant. The private investigator's report from March 2024 shows significant drinking and choosing to get behind the wheel and putting himself, no, he didn't have his children with him. I guess we're lucky on that, but he put everybody else at risk after drinking excessively twice and getting behind the wheel. And that's just in March. Probably more if he was still being followed by a private investigator. The amount of drinking that a parent with his history that is acceptable is 0. He needs to prove that he can control himself. Dad's mental health and his self-control. I don't care how mad dad was at mom. There's 0 justification for how he communicated with her. It's scary that a person with his age and education, he's not a 19-year-old young man who lacks self-control. At his age and education, he should have the self-control not to make her evidence for her in the middle of the night with those written communications. They show a complete lack of self-control. His words and actions when he knows that he was in the middle of custody litigation, being followed by PIs and being recorded in his interactions with mom, it's just shows complete lack of self-control. What anger management treatment, if any, has he ever had, Mr. Standish?
Well, he has not had those classes and they've not been ordered by the court, Your Honor. But I would like to comment on some of the things the court has said, if I may, after you're finished here.
Okay. And has dad engaged in the last year in any personal therapy?
No, Your Honor.
Right. So, with regard to my question of what is his work schedule, is he working at normal law firm Monday through Friday schedule? Or
yes, and he works mostly from home, so that makes him available to take care of the children. But he has a full caseload, and he is actually been offered a partnership at the firm. And if I can do an offer of proof today, I mean, his supervising partner would say that his work is very good.
Okay. And what kind of work does he do at BI?
Insurance defense work. Insurance
defense. Okay. That just gives me an understanding of the type of practice and the type of workload he has in that. So what I need to see in order to increase dad's custodial time and lift any driving prohibition. I want him to do hair and urine testing. It's been a while since he's been tested. I know he's tested positive for cocaine in the past. I'd like to have a clean hair and urine to help make me feel comfortable. I'm not trying to set him up for failure. I'm trying to say these are the things I need to be comfortable with him having more time, and particularly comfortable with him driving the children. Yes, if he's going to have more time, I understand he doesn't want to be stuck at home with them. Personally, I don't think the backtrack is enough. I think he needs a scram bracelet. That's what I need to see. I need to know he's zero alcohol and show that he has no problem controlling himself when somebody is there, and zero tampering. People try to tamper with those and they get caught. Third, I'd like to see him getting some counseling. It could be somebody covered by his health insurance. I'm not trying to make him incur more than he already has in there, but I need him to be working on somebody with stress management, impulse control, why he overreacts to stressful situations. Those are the three things I'd like to see before I increase his time or say he can drive with the children. The issues, scram bracelet shouldn't take that long for him to get. And then if he does the drug testing today, I'd like him to do it by 2 p.m. You say he's working from home. So, Mr. Houston, would you have the ability to go today before 2 p.m.?
I guess. I mean, I have one of my kids with me and I can't drive with them. So that's putting a
Could
little.
we have it tomorrow, Your Honor, so he doesn't have to lose time with the children?
That's fine. Oh, as long as, let's say, they open, I think, at 9. So
Yeah.
can you get there by 10 o'clock tomorrow morning, or do you have, if you have a deposition or something, I need to know that.
I can do it tomorrow at 9.
Okay.
There's a serious misconception about what I was required to do under the backtrack order. It was not to test. There's no such thing as 1400.
Can you
Okay.
address that, please, Your Honor?
I understand. I understand what you're saying. These children are very young, and there's a lot of history here, and I want to be sure that they're going to be safe. And I get it. If he's going to have, let's say he has Saturday and Sundays off. What if he has Saturday morning till Tuesday morning? Okay, that in theory would be good. If he has a scram bracelet on, I'm less concerned with that. Then he drives them where they need to go. I'm less concerned. I need to know he can control himself and do the things he's doing. I don't know if he's an alcoholic or just a binge drinker. I'm not qualified to diagnose him. I can see that he can refrain. So then if it's just a lot of drinking and then bad choices of getting behind the wheel and putting these children's safety while we're under this. I could just say no and make him wait till December. I don't think that that's reasonable either. I think that he could do things to help make me feel more comfortable with him doing this and having extended time, including overnight, and get back to a regular schedule with his children. So what I'd like to do is, if he's willing to get on the scram bracelet instead of doing the backtrack, do drug testing tomorrow morning by 10 a.m. That's hair and urine at ATI. I can do that referral and find a counselor. Hopefully he has medical insurance through his employer. Then we could come back and know that he's on the scram bracelet, has a clean drug test, come back on 10/14 or 10/17. And you guys can appear by Zoom. I'm okay with all of that. I don't particularly, I need you guys here for trial, but I don't particularly need you guys all to come down for this hearing. My goal, and maybe the interveners to know where I'm going, you may be able to resolve that. I get that they're going to want to have weekend time too. So there's some schedule that I can put in place. If he has this scram bracelet on and he shows me a clean hair and urine test, and that he's at least looking for a counselor who can work on these things. It is stressful going, and 2 years of nonstop custody litigation is enough to make anybody go crazy. But having deal with those stress, I'm saying crazy in a facetious manner there, it's enough stress in itself, let alone everything else that's going on in your life, and being a litigator, those are stressful things, and having more stress coping tools in his toolbox would be helpful for him long-term anyway. I'm not asking him to do something that's going to harm him. I don't think the scram bracelet, having that on would be, I don't think it's much more expensive than the backtrack. and I would like him to do the drug testing. So, Mr. Standish, you can go ahead, and that's where I'm.
Let me clarify
go.
first, Your Honor, and then I do have some remarks there or some queries for the court. One test at ATI right away. Is that what you're saying? Or do
Yes.
you want continual testing?
No, I want to see that he's got no drugs in his system.
Gotcha. Okay. By the way, there was another test, which we've never, even with your order, Mr. Jones has never sent it to us. So, I mean, I guess he's just going to disobey your order, but I'd like to get that released. So at least it shows that my client not that long ago voluntarily tested. And
do you want to do a court order that gets ATI to release? Is it with ATI?
No, I think Mr. Jones should give it to us. Why is he disobeying your order outright, like contempt?
I don't know if he's been served with the order yet.
Well, he was there at the hearing. Your Honor.
Was he at that hearing? I don't know.
With respect,
he was not at that hearing.
We'll get the count. We'll get a therapist in place, Your Honor. We'll certainly get the scram bracelet that you said. Was the court setting a date for the 14th or the 17th?
That's what I'm asking counsel, which is better for you. I have either morning, either one. I want to see those things in hand, and you guys see where I'm leaning towards. If he's doing those things that I'm asking him to, he's addressing my concerns, and let him have more time, and I'll let him drive the children around so that he can have normal time with them. Drop off his daughter at school on Monday morning.
What time would it be on the 14th or 17th?
I have 14th. I could do 10:30 would be good. I have nothing at 10:30 on the 14th, or I'm pretty open on the 17th. I could do it 9 o'clock in the morning. Nothing else. I'm not going to put any calendar calls on at this late date. So either
9 o'clock on the 17th would be my preference, because I have to come down for a different court hearing anyway in front of another judge.
Well, I'd rather have the 14th if we could, Your Honor. I was actually supposed to be out of town that day. I could delay my departure, but if we could do it at 10:30 on the 14th, I'd prefer it if we could.
Okay. Can you do that?
I believe on the 14th.
Yeah.
I assume.
Yeah. I mean, and you guys,
if you guys, fine, Your Honor.
If you guys can talk more and resolve it, you don't need the hearing. That's great too.
I understand, Your Honor.
But if you do, I'll make a decision on what I'm looking at is him doing that, being able to be a normal participant in his children's lives, such as dropping off his daughter at school, picking her up at school, talking. There's things you do when you pick up your children at school or drop them off at school, and talking to other parents, talking to the teacher. Those kind of things are normal parenting things and involve him in. That's what I'd like to see. If he's addressed my safety concerns, then I'm going to allow him to have more time and to drive the children. But if the scram has to be set up the same way, that any violation reports are also sent to, who's getting the backtrack? Are you counsel?
Currently, it's going to Lexi, Your Honor.
It's going to Lexi. Okay.
If we could have it go to Paul Page instead,
we can have it go to, I don't care if it goes to everybody. We all get alerted that there's a violation. I mean, I've heard of cases where people try to stick a credit card in between the leg and the monitor and stuff. So if a tamper alert comes or a violation alert comes, and I'm not looking to, I mean, Mr. Houston's an adult, and he can make choices to have adult beverages when his children are not in his care. That's why I understand the way Judge Henderson set up that order. I want to see if he can refrain between now and trial. That's what I'm looking to see.
Well, and
I'm not looking to put him permanently.
That's why there is no 1,400 missed tests, because I was required to test when I
only
had
then. I understand that.
So there is no 1,400 missed tests.
I just wanted to ask the court. I'm not trying to tell you to change your order in any way, but the other side has argued a lot of things that sound very bad. I understand the effect of the Alden Becker reports from this earlier this year, but we went through every single line of the backtrack reports. There were never 3,000 tests or anything close to that. Every single time he was required to test, we went through it because the orders were different. The November 22 order is totally incomprehensible. We don't even know what that was. But in May, it was real clear that in the May 2023, April 2023 order, April 17th, he was to test 8 hours before, and he was to have 4 tests today by day, each day, by random prompts during his custodial time. So really, we went through, he never really missed a test. Maybe twice you could say he missed a test that was, you know, physiologically relevant with the way that alcohol dissipates out of the body. I just wanted to point that out to the court. And
well, he was also supposed to
never positive in the presence of the children. We showed that It proved it. The backtrack records nail that at 100%. So I just wanted to enforce that for the court.
Again, it's not a badge of honor here to say, oh, I chose to go out the night before and get blasted, and oh, I left my kids with my parents. That's not like great parenting there. No, he was supposed to refrain. I understand, but he's supposed to refrain 12 hours before.
I understand.
So I get it.
Not the order at the time. That's the whole point, Your Honor. That was not the order at the time.
I'm not going to argue what the order was. I get there's some orders that changed over time. That we all, Mr. Standish and I, and Mr. Wiggins, that we were not all involved in that. So all of us are looking at a piece of paper and saying whether it's understandable or not. At this point in time, I want to go forward from today. We've made progress in that the pages have agreed that Dad doesn't need supervised visitation. That's a progress. And I'm looking at where the weaknesses are in my concerns for the children when they're so young. That's what I'm saying, is that I need these things to show that Dad can control himself and get all the tools he needs to do that, because some of his behaviors looked out of control and not safe decisions for himself or others. And I want him to be
one issue with the children and me in the entirety of this custody case. It's that simple.
I understand, Ms. Houston, you might want to take the advice of talk to your attorney and make sure before you speak out, because it doesn't help me that you're speaking out when you have counsel who's very experienced and is going to advocate on your behalf. So I'm just telling you what I'm new to this case. I don't know all the background, and some of it's not going to matter anymore. But I want to say, are these two children safe in your care? I want you to have the opportunity to prove that to me, and you may be right and prove it, and then the rest is what we deal with at trial.
No, Your Honor.
Yes.
For the record, we appreciate the bright line of your order. It'll help everybody in the case, including my client. So we appreciate the straightforwardness of it. We'll get right on it.
Okay. And then, like I said, if you guys can work it out and looking at what's there, there's a lot of moving parts. And I also want to make it clear to everyone that I've decided that my idea of being efficient really isn't what's best in terms of the guardianship of the estate. I'm going to handle that completely separately. It just too much overlap, and those issues are narrower in there. So we're not going to, I already told you, we're not going to deal with the guardianship of the estate at the trial we have scheduled on December 30th. I did schedule in the guardianship case a hearing because we do need to extend the temporary if there's still going to be a contest on that. And Mr. Standish, frankly, it's really, your client does have a conflict of interest at this stage in time. He's entitled to be involved in it, but I think it's reasonable for the pages to say we don't trust him to be the decision maker on that at this time. Once everything's marshaled together and we have a pot that belongs to these two children, then a different order. So I don't know if it's worthwhile for everybody to go to a trial over who should be the guardian of the estate right this minute.
No, we were never in disagreement with that. The conflict was too obvious.
Okay.
Because it is his father's estate and they're affecting his mother and so forth.
Right. And yes, and it's just cleaner for him to say, I get to observe, I get to make sure doing there, I get to be involved, but I'm not the guardian of the state right now.
Yes, well, that's actually helpful, I think, to everybody not to have it as part of the trial. So we will work those things out, or
right, or
you can set it. But I think
right, and I have
all those issues.
I agree.
It should go smoothly.
That, and if we're not going to have a contest on it, I could also right now appoint Mr. Page as the guardian of the estate long term, and of course all the normal stuff would happen there that we've already had hearings on some of it. Then we don't need to keep having we need to keep having hearings on the guardianship of the estate because it's only a temporary. That's all.
As long as we are clear on the record, it's reserving Dylan's right to ask to be a co-guardian. Like you're saying, after whatever is recovered, then it would simply be, if there's money there, there would be money there. And then I think co-guardianship would be appropriate.
Right, because there's for these two children, there's two sources of possible. One is the wrongful death claim. The other is whatever their mom owned, they're part of mom's estate.
Yes.
On that. And then having to do that would be clean. So if he consents to it at this point in time, Mr. Page with the court supervision would be the guardian of the estate. I can appoint him today, and we don't need to keep having hearings on that until something comes up. He's going to have to ask permission to do things like
Yes, that's fine, Your Honor, but the word consent gives me a little caution. As you know, with respect to a custodial issue of the person, we have a whole tortured history of our case law on that, what the burden of proof is, whether best interest applies and so forth.
Right.
So
No, I
it's just for the financial.
Right, for the estate only, to allow Mr. Page to more be the director and come to the court when it's necessary, to try to get their assets, whatever are available.
I would rather not consent on the record. I'd rather be on the record saying that he should be co-guardian at this time and just not participate in the other part. But I understand you want to make it clean, so.
Yeah, that would be my preference right now, is to, and if we appoint Mr. Page right now with the understanding that once the assets are marshaled, then it's a very different course of action. Right now, to get the assets to pursue the wrongful death claim is a different set of work than, okay, now we've got a pot of money for these two children. We're going to put, what are we going to do? Because they're very young. They can't have it till they're 18. What do we do? Do we need, and then do I need a budget? Those are all the normal things I do in any guardianship of the estate.
We have no objection to the court revisiting after the assets have been marshaled.
Right. So with that understanding, Mr. Standish, it's in your, I guess, in your thing to tell me what I need to do. Do I need to have more hearings on the guardianship of the estate right now? And I obviously can't, on the physical custody of these two children, we can't proceed under the guardianship only because in the guardianship case, I can't do a visitation when they've done a petition in the alternate for visitation. So that's why we're proceeding still under. I'd love to just close the D case, but I looked at the petition carefully.
Your Honor, we understand you're appointing Mr. Page as the guardian over the estate of the children.
Okay.
And for any other orders that the guardianship may need, such as when they were choosing an attorney or in case of settlement, then I don't know why Dana and I would not be able to stipulate, but she just needs to let me know. And then if you need it, obviously, then it'll come before you. But we think we can work out anything rational on that regard.
Right. What is all there? I don't think any of us know today what's available to these two children to put away, but whatever is will be preserved for them either long term. Like, I don't know if they are able to apply for any Social Security benefits. I don't know if mom worked and had a record there or not. So those kind of things I would look at when it comes time to that. So right now we're going to appoint Mr. Page as guardian of the estate. I'm going to vacate all of the other guardianship hearings. So we don't need any, we don't hear, I had it set for 10/8 on whether we're extending the temporary. And for some reason, the trial dates are still on my calendar. So we're going to vacate everything else. It'll next come before me when it's time. We're also going to stay any annual accountings. I think that's already in the order. Stay any annual accountings until there's something to account for. So the next time is going to be when Mr. Page needs permission to do something, like settle or do something else he may need to do. I'm not an expert at personal injury or wrongful death claims, so.
Your Honor, just to give you an update too, they have applied for Social Security and they have started receiving it, and it is in a segregated account.
Okay.
Sorry. Social Security does not need to go into a guardianship estate. That is separate and apart from a guardianship piece that is primarily for the caregivers, and if they don't want to use it, they're of course welcome to save it, but does not need to be accounted for. The other thing we would need to extend the deadline for, or have one and just have be blank and updated, is inventory. That's 60 days.
Right. It makes no sense to me, Mr. Wiggins, for them to file a blank inventory. So that the inventory would be filed within 60 days of there actually being an asset in there. I'm not trying to run up attorney's fees doing just busy work here. I want them to do what needs to be done for the children. And Ms. Dalia-Hunt's right that we don't include now the Social Security benefits into a guardianship estate. Now, if dad ends up the result of the trial or settlement is dad has custody, there may be an argument that he should be rep payee, and that will happen at that time. Right this minute with them being, and are we going to just update the order for reality? I think you guys agreed on the reality is that Mr. and Mrs. Page are the temporary custodians.
Yes, we'll take care of that one.
Okay, so you guys will take care of fixing an order on that. I will sign an order right now, Mr. Dwiggins, appointing Mr. Page as the guardian of the estate. And then we'll go from there. Sign the order for the drug test referral. So we'll give that to you, Mr. Standish, so you can get that to your client. So you can do that by 10 a.m. tomorrow. Anything else we need to handle today?
I don't believe so, Your Honor.
I think that's it, Your Honor.
Okay, then I will see you guys on the 14th if we need to, and we'll have more information then.
We're doing a written order for this hearing?
Wait, you can wait to do the written order. Then we can, because we need to fix that Mr. and Mrs. Page are the temporary custodians of the children.
Very good, Your Honor. Thank you.
But and we're going to fix it because there's going to be some different order regarding dad's time, his custodial time, and what those look like. Okay.
Thank you.
All right.
Thank you, Your Honor.